very last paper. A few bits and pieces of information just before then. When we finish, we're going to go straight to dinner. A couple of people can't make it from amongst our crowd. Sorry, you can't come. They've got other things they need to do, but everyone else is going to be going straight to St Hilda's just for time reasons. It's about a 10-minute walk. If anybody needs any difficulties getting there, let me know. But essentially, we're just going to go along Merton Street, up onto the High Street, along the bridge, and we turn right, and you're into St Hilda's. It's not a massively difficult journey. I think the weather's okay, so we shouldn't have problems there. And we'll be finishing there, so don't leave anything here. We will have to just grab a couple of bits and pieces from the room. Rachel, are you okay taking it? Yeah, so Rachel will be leading you off, and I'll catch up with you once you've done it. So that's what will happen immediately when we finish. There isn't time to grab more cakes, but don't worry, it is a three-course dinner. So now, on to our final paper, which hopefully you all have the handout for. Wonderful. We are moving, as I said, on towards the law of procedure. And is it time to call time on unsafe acquittals? This is a paper by Jarvis, and we're incredibly lucky, fresh up from the courts, to have Lord Justice William Davis with us, who's also chair of the Sentencing Council, which is obviously quite a lot to fit in, so it's amazing that he's able to join us today. So, without further ado, over to you, Paul.
You've had Rachel starter, you've had Jonathan's main course, and now the dessert that you've all been waiting for, criminal procedure. Who does not love it? We're very fortunate at the Assize seminars to have a very interesting mix of people, different stages of your careers, different backgrounds. I'm not going to make any assumptions about how much any of you will know about the rules of criminal procedure in the context of the appellate courts. But it's interesting, I think, to begin by contrasting how the defendant's rights stand against those currently enjoyed by the prosecution. So if you, the defendant, are convicted by a jury, then you enjoy, as some of you will no doubt know, a right to seek to challenge that conviction before the Court of Appeals, who will set it aside if it is unsafe. There are time limits for the exercise of that right, but they can be extended by the court at any time up until your death. And even after you die, somebody can be appointed to bring an appeal in your stead. So what that means, in effect, is that any defendant who is convicted by a jury has a right of appeal against his conviction that exists in perpetuity. Prosecution has no right of appeal against an acquittal. Why does that position exist here in the law of England and Wales? Acquittals traditionally have been regarded as sacrosanct. There have been very limited ways in which the prosecution, or indeed the courts, have been empowered to seek to set aside acquittals under any circumstances, whereas traditionally the defendant, as I've said, has always enjoyed the ability, without seeming limit of time, to have any unsafe conviction set aside. People often raise as a justification, well, double jeopardy, that is the principle that would stand against the idea of the prosecution being able, under any circumstances, to invite the Court of Appeal to replace an acquittal and to invite a defendant to be retried for an offence for which a jury decided he wasn't guilty. It's interesting to note that there are lots of countries, in particular in continental Europe, who do recognise the ability of an acquittal by a prosecuting agency. And that's partly recognised by the way the European Convention approaches the question of acquittals. So Article 4.1 of Protocol 7 sets out, for example, a right for a defendant not to be tried or punished twice, but it contains two notable exceptions. And those exceptions find form in, I say, a lot of jurisdictions where the countries are signatory states to the Convention. The first is where the acquittal has arisen as a consequence of an irregularity, however we would define that. I'll come back to that shortly. The second is where there is something new or compelling that emerges after the acquittal has been returned, which tends to cast doubt on its veracity. Again, I'll come back to that in a moment as well. For those who are familiar with the International Covenant on Civil and Political Rights, then you will know that Article 14.7 again prohibits somebody from being tried again who has been finally acquitted. Although it's worth noting that jurisdictions that recognise the ability to challenge an acquittal would say the fact that such a right exists means that acquittal does not become final until the right has either been exercised or ignored, and therefore there's no breach of that particular provision of the ICCPR in circumstances where states recognise a statutory route to challenge a criminal acquittal. There have been occasions in the last 40 or 50 years where Parliament has had to react to the fact that there will be situations where acquittals need to be interfered with. And I mentioned, first of all, this idea of an acquittal having been returned because of an irregularity. We now have Section 57 of the Criminal Procedure Investigations Act 1996, which allows an acquittal to be overturned where it's been procured by misconduct that might be equivalent to perverting the course of justice. So jury tampering. We now have a rule that would allow an acquittal to be set aside if that acquittal had been returned because the jury had been interfered with by somebody intimately connected to the case. We also have, under Part 10 of the Criminal Justice Act 2003, again, as some of you may know, the ability to set aside an acquittal where there is compelling new evidence that comes to light of the defendant's guilt. And that change came about because of work done by the Macpherson Committee, looking into, for example, the circumstances surrounding the murder of Stephen Lawrence, and whether we ought to be able to recognise situations where genuinely new and compelling evidence casts the trial in a very different light, such as would justify the defendant who'd previously been acquitted being retried. The Law Commission looked into it. There's a very interesting consultation paper and Law Commission report talking about the limits that ought to exist in those circumstances where we'd even be capable of contemplating the possibility of overturning an acquittal where there is new and compelling evidence of guilt. As you might imagine, it's a jurisdiction, the exercise of which is very tightly confined. Only the Court of Appeal can give the prosecution permission to proceed, and will only do so where it's in the interest of justice. So the very fact that you have new and compelling evidence of guilt on its own is not sufficient to enable the court to set that acquittal aside and order the defendant to be retried. But that's the limit of what the law of England and Wales would say in relation to allowing acquittals to be reviewed by a higher court. We do have an ability that vests in the Attorney General to invite the Court of Appeal following an acquittal to give us the benefit of its insight into what the law is. So if there is a contentious issue in a case and there is a sense in which the judge has fallen into error in his interpretation of it, the Court of Appeal can be invited to consider it. But importantly, that jurisdiction does not interfere with the acquittal itself. The best it does is regulate the law for the future. It cannot interfere with an acquittal return, even an acquittal return following an erroneous legal direction favourable to the defendant. What's interesting by way of contrast is that while acquittals returned by juries are generally treated as being beyond reproach, we don't have the same self-denying ordinance when it comes to acquittals returned by a magistrate's court. So if the magistrates find you not guilty, the prosecution in England and Wales have the opportunity to challenge that acquittal before the divisional court in what's called an appeal by way of case status. In other words, you can say there was a legal error made by the court, which may well have led to the return of a not guilty verdict, and you, the High Court, in your supervisory jurisdiction over the magistrates, can set that acquittal aside and take whatever remedial action you think is appropriate on the facts of the case. And so we seem to have a situation where the less serious the offence that you stand acquitted of, the more likely we are to recognise the ability of the higher courts to overturn it. The more serious the offence that you're acquitted of, the less likely it is that we are willing to give the higher courts an opportunity to scrutinise the safety of that acquittal and set it aside if it's found to be unsafe. One of the things the Law Commission looked into, and it may be a partial answer to the question, well, why don't we allow the prosecution a general right to appeal against acquittals? Now finds form in what's Part 9 of the Criminal Justice Act 2003, and it's the ability of the prosecution to appeal against what we might call our interlocutory rulings of the Crown Court. And again, for those who don't know, the prosecution has the ability to challenge the rulings of Crown Court judges if they are wrong in law. That's an appeal that goes to the Court of Appeal. it's an appeal that will be brought before that trial reaches its conclusion, and it's an appeal which the prosecution can pursue effectively as of right without needing the permission either of the trial judge or effectively the Court of Appeal, although permission and the substantive merits are often rolled up into one. Nowadays, as a matter of practice in the Crown Court, judges' directions are delivered to the jury in writing. They're the product of a discussion with the lawyers in the case. Very often they are agreed in the loose sense that the lawyers don't come to the view the judge has made an error in the direction she proposes to give to the jury. And it might be said, well, given you have this interlocutory power, if the judge proposes to give the jury a direction of law, which you, the prosecution, say is wrong, then why can't you just use your interlocutory power to challenge it? And if it's wrong, the Court of Appeal can set it aside, put it right, and the trial can proceed on a correct legal basis. Do you therefore really need the ability to challenge an acquittal, which has been returned on the basis of an erroneous direction of law? I think there are three answers to that. There are three problems with saying that an interlocutory right of appeal is a good substitute for an appeal against an unsafe acquittal. The first of those, it tends to assume that people involved in the trial know that something's gone wrong. And sadly, that's not always the case. A lot of appeals against conviction in the Court of Appeal arise because somebody unconnected to the trial process has had a look at what went on and discovered an error that calls for correction. So it's not always going to be the case, for example, that the prosecution in the trial will be aware that the judge has fallen into error. That possibility may only emerge once the trial is concluded. As an example of that, you might want to think about the Colston case in Bristol, a very recent Attorney General's reference on a point of law, where the Court of Appeal emphatically concluded that the jury had been left a defence for their consideration, which simply wasn't available to the defendants in law. This idea that the jury could acquit the defendants if they felt that a conviction was a disproportionate reaction to that prosecution. The Lord Chief Justice said that was not a direction the jury should have been given. That defence should not have been left for the jury. They may well have acquitted on the basis of that defence, in which case that acquittal would be arguably unsafe. But nevertheless, because it's a reference on a point of law, the Court of Appeal is powerless to correct it. But it's a good example of a situation where the lawyers involved in the case were themselves unaware that the judge had fallen into error. An interlocutory right of appeal is not going to achieve the ends of justice unless those involved in the exercise of that right are aware that an injustice has occurred. The second point about the exercise of prosecution interlocutory rights of appeal is that there is a sting in the tail. When the Law Commission was proposing to give prosecutors this right, one of the consequences that's featured into legislation is the idea that you, as the prosecutor, have to agree that the defendant will be acquitted of the crime if your appeal fails. In other words, if you try and challenge a ruling of the Crown Court judge, whatever that ruling may be, and whatever the substance of it may be, if the Court of Appeal find that it was not wrong, then the only outcome of that unsuccessful appeal is the defendant's acquittal. That, you might think, places prosecutors in a fairly invidious position. Because if the ruling is not a ruling that brings the case to an end anyway, then you may well bring about that result by seeking to have that ruling overturned. And so if there is an erroneous direction of law the judge proposes to give the jury, but it's not a direction that could fatally undermine the prosecution's case, you may decide the better course is to take your chance and see if the jury convict regardless. But if you do that, then you've got no avenue to correct that outcome if there is a genuine concern that it has been arrived at because of that judge's error. That's part of the reason why this interlocutory power of appeal is really only exercised in those cases where the judge has made what we might call a terminatory ruling, because then there is no comeback to the prosecution. The outcome that you're seeking to avoid is one that you can't. The judge has already decided the case will end. If you enter into an acquittal agreement and the appeal fails, you're in no worse a position. So it's a bit of a loss leader. But is it really a satisfactory response to the prosecution? to say any appeal against an acquittal that we might give you is unnecessary because you can challenge these rulings in the course of the trial, even though there are very good practical reasons why you might not want to do that. Think, for example, about a murder case where the judge decides to leave loss of control or diminished responsibility where it is unavailable on the law. If you challenge that ruling and you were unsuccessful, the defendant will be acquitted of murder. The third point is that the interlocutory powers of appeal enjoyed by the prosecution terminate when the summing up begins. That's what the statute says. So it's not every ruling the Crown Court judge makes that you can challenge. Now, there are good reasons for that. You might be more willing to consider interrupting a Crown Court trial before the jury are in retirement. If there's a delay of 2 or 3 days or a week while the Court of Appeal decides if the ruling is correct, we might be able to live with that. But we're much less comfortable with the idea of saying to defendants or jurors, you'll have to park your deliberations for a week to enable this ruling to be assessed if it's a ruling that comes once the summing up has begun. Why might that be significant? Again, it's not uncommon. You've all seen cases where jurors in retirement come back with questions about the law that requires the judge to give another direction. And if she delivers a direction that's wrong in law, and if the prosecution say this is incorrect legally, then there is no way that they can challenge that, absent allowing the prosecution to have a right of appeal against an acquittal, if it's an acquittal that follows. So my suggestion to you is that there is no present right of appeal that the prosecution currently enjoys, which comes anywhere close to being equivalent to a right of appeal against an acquittal. But that doesn't answer the question, well, why should we give the prosecution a right of appeal against an acquittal in the first place? What is the justification for saying that the prosecution rights and the defence rights ought to enjoy a degree of symmetry? I can't really improve upon what Justice Labelle said in the Canadian Supreme Court case of George. The Canadians recognise the general power that the prosecution have to appeal against acquittals. There have been, in the very early stages of those reforms, a number of constitutional challenges in Canada where the argument was the existence of such a right is contrary to principles of double jeopardy and the Canadian Charter. And he said this, must be recognised, the appeal function is an important component of a legal system whose purpose is to ensure that the rules of criminal procedure and evidence are properly applied. The accused has a right to a fair trial in accordance with the substantive and procedural rules of criminal law and the principles of the Constitution. The Crown, which represents the state in the public interest in the proper administration of criminal law, has the same right. It is that right that is protected by the existence of an appeal function, which must be performed with care, but firmly when the need arises. So the right to a fair trial we commonly think of as being a right owed by the state to a defendant, but it's equally a right owed by the state to the prosecution. The trial is not just fair in one direction. It's either fair overall or it's not fair at all. So there is, on this point, we say in principle, a need to establish some degree of parity between the prosecution and the defendant when it comes to setting aside outcomes, whether they are convictions or acquittals that have been procured by, for example, a significant misdirection of law. Across common law countries, this right is recognised, and a number of Caribbean jurisdictions have created or amended statutes in the last 15 or 20 years to give the prosecution this particular right. There are concerns about its overuse. There were concerns when interlocutory rights of appeal were introduced in 2003 that the prosecution would go haywire. They'd be challenging decisions left, right and centre, grinding trials to a halt with every decision the judge takes, which the prosecution took umbrage. That, I'm glad to say, has not happened. But it would be wrong to suggest that if there was to be a right of appeal against acquittals, that ought to be an unfettered or unrestricted right that the prosecution can enjoy in precisely the same way the defendant can. I wouldn't be sitting here suggesting that a prosecution right of acquittal ought to exist in perpetuity in the same way that a defendant's right to overturn his conviction could be. There are lots of restrictions that other countries look to impose upon the exercise by the prosecution of a right to seek to overturn an acquittal. I'm going to suggest a few of them for your consideration. You can restrict the types of offences in respect of which that right arises, limit it to very serious offences, murder, manslaughter, genocide, those sorts of crimes. You can restrict the way in which the prosecution exercise that right. You can impose an immutable time limit upon it, exactly as arises in unduly lenient sentence appeals, where the time limit cannot be extended by force of God or indeed the Court of Appeal. You could require approval at a very high level, whether it be the DPP or the Attorney General, before the prosecution exercise this right. You could empower the Court of Appeal to allow the acquittal to stand, even if it's been procured by a significant misdirection of law, if it wouldn't be in the interest of justice to set it aside, or to order the defendant to be retried. So there are lots of ways in which we can deal with people's concerns about how a rampant prosecution power to overturn acquittals could be the subject of misuse. But if we seriously mean that a fair trial means fair to all, not just the defendant, not just the prosecution, but the victims of crime, then maintaining a system that requires us to say to them that regardless of how egregious the error of law might be, the acquittal returned by this jury is immune from criticism in the Court of Appeal, and the person who may have been unfairly or improperly acquitted is entitled to the benefit of that unfairness, because we refuse to recognise the ability, limited though it may be, of the prosecution to invite the Court of Appeal to intervene and set it aside, may not in fact be doing justice to a great number of cases in this country. And that's the reason why the purpose of my paper is really a plea to the Law Commission, which is in the process, as presently understood, of looking at criminal appeals within the jurisdiction of England and Wales, to have on its agenda the possibility of considering whether a prosecution right to appeal against acquittals ought to be something to be taken forward, with the possibility of legislative intervention at some point in the future. You've been very patient. There's a very powerful person sitting to my right, championing at your bit to have something to say, so I'm going to let him say it.
Paul not infrequently appears in front of me, us, and I won't spare his blushes. If he's there, we think, right, we're going to get the case properly argued, whichever side he's on. But I assume that the purpose of this evening would be rather destroyed if I simply said, well, I agree with him. So I shall try and think of some reasons why not to agree with him. The Law Commission, when they were deciding that, yes, there should be some right of appeal against acquittals, or say recommending rather than deciding, which led to the institution of the tainted acquittal process, where an acquittal's procured by intimidating witnesses, intimidating the jury, perverting the course of justice, or the acquittal that should be overturned because of new and compelling evidence. The Law Commission did consider the very proposition that Paul is now putting forward. And they said this: in our consultation paper, we provisionally concluded there should be no right of appeal by the prosecution against a jury's verdict of not guilty, even where there's been a misdirection by the trial judge, which may have favoured the defence. There was virtually no opposition to this conclusion, and none from any practitioner or judge. We therefore can see no reason to depart from it. We make no recommendation for the prosecution right of appeal against misdirections to the jury or acquittals arising therefrom. The interlocutory procedure that Paul has described post-dated that and does, as he acknowledges, provide a route to challenge a trial judge's ruling of law, which includes the direction he proposes to give to the jury. When that conclusion was reached, the landscape of English criminal trials was really rather different to how it is today. I can remember in about the time that paper was being issued, I was doing a trial in front of a High Court judge. I was prosecuting, 2 other Silks defending, and we provided the judge with, I think, a 2 sides of A4 set of, not directions, they were just questions that the jury needed to have answered. And we were suggesting it might be a good idea actually to give the jury this document. The High Court judge involved was horrified, thinking the document was vastly too complicated, and she certainly wasn't going to do that. And even as late as 2010, when I first went to what they call the homicide seminars, where Court of Appeal, High Court judges, at that time the Recorder of Birmingham would go, people who tried homicide, and at that very first seminar there was a discussion of written directions, and it was not completely poo-pooed, but some really very senior judges. I can remember one asking, well, when is it I'm supposed to write these directions that the jury are going to have? People under their breath would say, well, at the same time you're writing it for the purpose of you delivering it orally. But anyway, that was the environment. And judges would deliver their summing up, very often without any discussion at all with counsel. And even in that situation, the Law Commission, in their wisdom, said no. And they said no, essentially because a jury's verdict, unless they can demonstrate it's tainted, or unless it can be demonstrated that they simply didn't have the evidence they should have had or would have had matters not developed as they did, is to be regarded as sacrosanct. The interlocutory appeal is not complaining about the jury's verdict. It's a submission of no case that shouldn't be allowed, off go the prosecution of the Court of Appeal, and they're complaining about the judge's decision. So that's, I suspect, why the Law Commission and why all these judges and practitioners to whom replied to the consultation, that's the reason. And it's undoubtedly right that one large common law jurisdiction, Canada, takes a different view. Significant numbers of others don't. Australia, no state in Australia has such a right of appeal. Paul has offered 3 reasons why the current position, where the prosecution, should they think it appropriate, because they will now get the written directions, they'll know what the judge is going to direct the jury, they know, should do, if it's wrong. He's offered 3 reasons why this just doesn't cut the mustard. The first is that the lawyers at the trial may not identify the error. My personal view is that allowing a jury's acquittal to be impugned because of incompetence of people at the court, which is what it amounts to, is a rather thin basis upon which to challenge what I regard as, in general terms, the sanctity of the jury. The second objection is, well, this interlocutory appeal has this sting in the tail. What if the ruling, the proposed direction, doesn't fatally undermine the case? And you said, well, I'll agree to an acquittal, and then you might find yourself with an acquittal on your hands when you might have been able to run it to a successful conviction. I would hope and expect that if the reality is that the direction being given might or might not affect the verdict, then even if this right existed, the Court of Appeal would say, no, we're not here to allow acquittals to be overturned simply because the direction was given that might have made a difference. It's very interesting to think what might have happened in the destruction of the Colston statue case, had there been such a right. And the Court of Appeal had been asking themselves, well, should we overturn the acquittal? Because there were 3 or 4 defences being run. And how were they to know which one the jury accepted? And it's quite right, as Paul says, that this right of interlocutory appeal ends when the summing up begins. But in today's environment, the notion that the parties in the case aren't going to know precisely what the judge is going to direct the jury before the summing up begins is frankly not tenable. So my perception is that the interlocutory right of appeal, introduced as it was post the last Law Commission, is something that gives the prosecution sufficient protection against these directions that undermine what appear to be legitimate acquittals. Paul used the phrase, a great number of cases. I'm very sorry. I sat almost permanently in the Crown Court from 2008 to 2014, and then regularly in the Crown Court. And I sit in the Court of Appeal now and have done for a number of years. I really can't think that there are judges up and down the country regularly misdirecting juries in a way that actually is leading to the acquittal of the defendants. It assumes a really rather unfortunate lack of any legal knowledge on the part of the prosecutor, and indeed on the part of the judge, who you'll be pleased to hear does receive occasional training these days. So it's my practical objection to the position. My view is, and the Law Commission may take a completely different view, that this is a solution to a problem that frankly doesn't in real life exist.
So one of the things that's interesting is the question about how the court would approach the exercise of deciding whether an acquittal ought to be set aside. So the point that Lord Justice Davis was making about, well, what exercise do we anticipate the Court of Appeal would undertake in answering the question, is this a situation where the acquittal ought to be set aside, assuming such a right were to exist? It's interesting, if you look at the Canadian cases on how they would formulate that test, the current best working definition is this. An accused who's been acquitted once should not be sent back to be tried again unless it appears that the error at the first trial was such that there is a reasonable degree of certainty that the outcome may well have been affected by it. And so there are lots of ways in which you might formulate a test. Let's assume there is a desire within the auditorium for such a right to exist. How would we frame it? It's always going to be very difficult to say, well, we have to be able to be sure that, but for this misdirection, the verdict would have been the exact opposite of what it was. But a test such as reasonable degree of certainty the outcome may well have been affected by it, some people might think that sounds a bit weak. And that really, if there is going to be a general right to appeal against acquittals, we have a stronger test whereby the Court of Appeal would only think about entertaining those sorts of rights where it could be confident to whatever standard that that legal error has had a bearing upon the outcome. And I'm not blind to the fact there would be an awful lot of disagreement about how you might formulate that test and how it might apply in practice. I take your point about, well, judicial errors. Where do they creep in? Is this something that isn't needed? The reality is there will be cases where judges have misdirected juries, and as a consequence of those misdirections, acquittals have been returned. The volume of those cases may not be something that we can detect. Luckily, Lord Justice Davis has the vantage point of sitting in the Court of Appeal and seeing what cases come before him. But it wouldn't take many cases, or many serious cases, where verdicts have been returned following errors that have either gone undetected at the trial, or have been detected, but where the prosecution, for good reason, have not taken steps to correct them, or where the prosecution have not had the power to correct them because the errors have only crept in once the summing up has begun, before there might be a movement towards saying recognizing the existence of a power like this is at least capable of correcting injustice, even in only a few cases. But if they're serious cases and the injustice is particularly grave, it may be better that we have that power than not. And when we look at, for example, the power that there is to set aside tainted acquittals that have followed, or Justice Davis said, perverting the course of justice or interference, I think if you did a Westlaw search, I'm not sure there's an authority on the exercise of that statutory power at all. But there it is. And it only takes one case where it's needed before the existence of that statutory power is justified. And so I would still say, notwithstanding the rather eloquent critique, that we do need a power like this on our statute.
I feel like I want to clap again. I'm not sure if anyone else is feeling that way, so I'm going to. Thank you both very much. That's really wonderful and stimulating set of discussions. So, can we do the same thing again?